What's credit got to do with it? How you can help tenants and workers using the federal and California consumer reporting laws. Next slide, please. So my name is Chi-Chi Wu. I'm the Director of Consumer Reporting and Data Advocacy at the National Consumer Law Center. With me today are two fantastic speakers. First, my colleague, Ariel Nelson, who's a senior attorney at National Consumer Law Center, and who focuses on, one of her focuses is what we're going to talk about today, tenant screening and employment background check screening. We also have Sparky Abraham from Jubilee Legal. Sparky is a private practitioner based in California who works on consumer reporting issues, among other types of consumer cases. And he's here today to talk about the California consumer reporting laws. We would love to know a little bit more about you. If you would want to put your name and maybe, if you're a legal services program, what program you're with in the chat, if that is enabled. And then, as Kasia said, for questions and answers, we are going to use the Q&A function of Zoom. So I am going to turn it over now to Ariel to talk about tenant screening and employment screening reports.
Wonderful. Thanks, Chi Chi. As we get underway, we wanted to make sure that we're all on the same page here about what we're talking about. And as I'm guessing many of you know, many landlords, most landlords now, use reports purchased from these specialized tenant screening companies to screen tenants. And I just wanted to list some of these big ones in the chat. You may have seen some of them. I'm sure you've dealt with some that are not listed here. But some of these include Experian Rent Bureau, TransUnion Rental Screening Solutions, which you can see have the same names as some of the big three credit bureaus, are part of their names, but they are specialized tenant screening companies. SafeRent, AppFolio, RealPage. These are just some of them. And I'm curious, please feel free to put in the chat if you have dealt with any of these or any others. Or we're always curious to see, who and which of these companies in which jurisdictions are maybe most prevalent. Um, and similar to the tenant screening context, we also have employment screening, and many employers use reports purchased from specialized employment screening companies. Um, and some of these companies include First Advantage, Sterling, Checker, Accurate Background, backgroundchecks.com, HireRight. Um, and similarly, these provide these reports, and we'll get more into later what is on them and what happens when things go wrong. But we just wanted to level set a little bit with some of these names that might be familiar. And here we go. So some of the info that is on tenant employment screening reports includes credit header information, and that can be things like address history, names. And as a side note, there are some jurisdictions, and and Sparky should remind me. I think California might actually be one of them where this can't appear. Sorry, I'll stop there. I was getting into credit reports. So credit header info, then there's credit report information, which is credit reports resold from the big three credit bureaus, Experian, Equifax, and TransUnion. So for example, when you look at a tenant screening report, you'll usually see a full credit report as part of that bigger report. Another big item we see on both tenant and employment screening reports is criminal records, sex offender registry information, National Terrorist Watch List information, which is the OFAC list, rental history in the case of tenant screening, eviction records in the case of tenant screening. There's sometimes an income and or employment verification. And particularly in the tenant screening context, we also increasingly see tenant screening scores and recommendations, which tell the landlord whether they should accept or deny or accept with conditions a rental housing applicant. And I'll turn it over to Chi-Chi to talk a little bit about credit reports in particular.
Yeah, thank you, Ariel. So the title of this webinar is What's Credit Got to Do with It? And that basically refers to the fact that the statute that we're going to talk about that governs tenant screening and employment reports and that you can use in your practice is the Fair Credit Reporting Act. And despite the fact that it says credit report, it covers way more than that, which we're going to go into. But credit reports are relevant to tenant screening and employment, as Ariel said. We know that about half of employers use credit reports in some or all of the jobs that they screen for, and 90% of landlords use credit reports and scores. Now, there's a big public policy debate about whether that's a good thing or not, whether it's appropriate. We have a primer on that particular topic, and that'll be sent to you. The link will be sent to you called Mission Creep. Um, but in addition to the fact that for better or for worse, credit reports are used in employment and tenant screening, the other thing about credit reports is that they do have a special role in the Fair Credit Reporting Act in terms of duties. So credit reports are provided by what are referred to as the nationwide consumer reporting agencies. This would be Equifax, Experian, and TransUnion. They have a special definition under the FCRA. They have special duties. For example, they have to provide free annual file disclosures, free annual credit reports via the centralized source, i.e. annualcreditreport.com. And actually, they are providing free weekly reports right now. So, if you need to help your client pull their credit report, they can do it once a week. The nationwide consumer reporting agencies or the big three credit bureaus also has special duties with respect to security freezes and fraud alerts. Next slide, please. So both the big three credit bureaus as well as tenant screening and employment background checks are covered by the Fair Credit Reporting Act. And we're going to go over the FCRA and sort of a primer or, an ABCs of the FCRA and its the obligations that it imposes on consumer reporting agencies for furnishers that supply information to a CRA and users of the reports. This is, we only have, somewhat over an hour, so this is going to be very basic. We're not going to be able to delve deeply into some of the thornier issues. However, there are resources out there. If you want to learn more, we have a legal treatise on the FCRA. And at the very end of this, we're going to talk about a training that is going to be available in Minnesota at the end of April, beginning of May, called the Spring Training. And we're going to talk about a special opportunity for legal services attorneys. There's scholarships available to that training. In a little bit, after I get through the next few slides, I am going to actually post the application form for the scholarships right away in case some of you need to drop off at the very end, so that at least you have the link to that in case you're interested. So next slide, please. So the Fair Credit Reporting Act actually governs a lot. The definition of consumer report and consumer reporting agency are very broad under the Act. So it definitely includes tenant screening, employment screening reports. The definition of a consumer report basically has two prongs. The first prong has to do with the kind of information in a report. And as you can see, an information that can qualify as a consumer report can bear upon 7 categories of information. 3 of them, creditworthiness, credit capacity, and credit standing, are what you probably think of with a credit report. But the other 4 categories, character, general reputation, personal characteristics, and mode of living, are incredibly broad. And as you can see, definitely cover things like criminal records or eviction records or employment histories or such. The other major prong of the definition is that it's information that's used or expected to be used or collected in whole or in part for certain purposes. And those purposes include establishing eligibility for credit, insurance, employment, or other authorized purpose. And so this kind of um, hooks in what I'm going to talk a little bit about in a little bit, the permissible purposes of what a consumer report can be used for under the FCRA. Now, as you can see, the information has to be communicated by a consumer reporting agency. So this is third-party information, and the definition relies on what's a consumer reporting agency, and the consumer reporting agency is a company that, for money or on a nonprofit cooperative basis, regularly engages in whole or part in assembling or evaluating consumer credit information or other information for the purpose of furnishing consumer reports to third parties. So the definition of consumer report refers to consumer reporting agency and vice versa. It does get very tricky. There are certain entities we know are covered by the FCRA. The big three credit bureaus, a lot of the tenant screening agencies and employment background check agencies that Ariel had in the slides earlier. There's a list that is maintained by the Consumer Financial Protection Bureau of consumer reporting agencies. If a company's on that list, it's a consumer reporting agency. However, that list is not exclusive. And we often see cases where there's a fight over whether the Fair Credit Reporting Act covers the entity or not. Those are tricky cases because even though this definition is really broad, courts often, or judges often, are a little bit surprised about the breadth and sometimes I think not comfortable. So we do see not great case law sometimes. So if you're trying to push the envelope and saying a certain company that doesn't think of itself as a consumer reporting agency is one, be careful. We don't want to make bad case law. Please reach out to us. Okay, next slide, please. The other important terms under the Fair Credit Reporting Act is a consumer file. So a consumer report is the information that's conveyed to a third party by a CRA. The file is everything that the CRA has recorded about that consumer. Now, in most parts of the country, there's a difference between the consumer file and the consumer report, and certain legal obligations only apply to the consumer report, like the accuracy obligations Ariel's going to talk about. However, you're in California, you're in the Ninth Circuit, and in the Ninth Circuit has said the consumer file and the consumer report are the same thing. The information doesn't have to be sent to a third party in order to trigger the obligations, some of the obligations that Ariel is going to talk about. The other two categories of entities that are regulated by the FCRA and very important to know are furnishers and users. So a furnisher is an entity that provides information to a consumer reporting agency. With a credit report, that's usually like a creditor, lender, bank, debt collector. With tenant screening and employment background checks, you usually don't have an entity actively supplying information regularly like a creditor. But what you do have as a potential furnisher, it is the public records vendor. So the court or the state agency usually isn't considered a furnisher because they're not actively supplying the information to the CRA. But you'll have a vendor that collects the information and supplies it to CRA. And one of the big ones is LexisNexis, which you've probably heard of. So that might be a furnisher. And then the other group of entities is users. And these are entities that pull credit reports, pull tenant screening or employment reports. So that would be the employer and the landlord, and they are subject to certain duties. So now I'm going to turn over to Sparky because he's going to talk a little bit about how these definitions are a little bit different under California law.
Yeah, thanks, Chichi. And actually, before I get started, again, in case anybody has to leave early, let me just say, when I was a legal services attorney, I used scholarships to go to the NCLC and NACA trainings as much as I could, and I highly recommend it. So I think Chichi is going to put that link in the chat. If anyone has even an inkling, I'm happy to talk about it. They are extremely, extremely useful. Okay, that plug aside. So we've been talking about the Federal Fair Credit Reporting Act. California has two somewhat parallel state laws that have some of their own little quirks and differences. The first one is the California Consumer Credit Reporting Agencies Act. These are reports under the California Consumer Reporting Credit Reporting Agencies Act are those that bear on the creditworthiness, credit standing, or credit capacity, and that are used or expected to be used for credit, employment, or renting. So first thing to notice there, right? Whereas the Fair Credit Reporting Act definition had 7 categories, and that included character and mode of living and all that, the California Consumer Credit Reporting Agencies Act are reports that are about credit. But then we have the Investigative Consumer Reporting Agencies Act. That is a separate law in California. And this defines investigative consumer reports to be broader, to look a lot more like the definition in the Fair Credit Reporting Act. This is any communication bearing on a consumer's character, general reputation, personal characteristics, or mode of living. So in some circumstances, depending on what type of report it is, it might be a consumer report under the Fair Credit Reporting Act. It might not be a credit report under the California Consumer Credit Reporting Agencies Act, but then it might be an investigative consumer report under the Investigative Consumer Reporting Agencies Act. All of these laws, as we'll talk about in a second, have relatively similar duties, but different sort of enforcement mechanisms and different remedies. But all that to say, if you have a person in California who has an inaccuracy on any of the kind of reports that we're talking about, you probably have a path to some sort of federal remedy, and you probably already have a state remedy under one or both of these laws. Again, they're just kind of these sort of technical differences in between. One other thing just to note quickly here, the Investigative Consumer Reporting Agency is defined here as any person that for fees or cooperatively prepares investigative consumer reports. And the Investigative Consumer Reporting Agencies Act is pretty restrictive in terms of what the allowed uses are. Those are employment, landlord, insurance, and investigation of wrongdoing, basically. Beyond that, people should not be able to get investigative consumer reports in California. I think I'm kicking it back to Ariel here.
Yes. So we've sort of gestured at the fact that these reports are often full of errors, and those errors can be really significant because they might result in someone not getting a job or not getting an apartment. So the most common types of inaccuracies we see are mixed files, or sometimes you might call this a mismatched report. But essentially, the idea is that somebody else's record appears on your report. So that could be a criminal record or an eviction record. And this is especially common for people with common names, unsurprisingly. And we'll get a little more into why that happens. Another common error is the reporting of sealed or expunged records. We also see an erroneous description of the case or the case level. So that could include something is reported as a felony, but it's actually a misdemeanor. And those things can be really significant because there could be some sort of policy that says someone with a misdemeanor can rent that apartment, but someone with a felony can't. So you can see how that would really result in a big deal for somebody. There's also issues with failure to update records or incomplete records. And this can include, a criminal record that doesn't include disposition information, or same with an eviction record where you see there's an eviction filing, but you don't see that the tenant actually prevailed. So similarly, huge consequences for people, often based on landlords' rental criteria. We also see reports that have the same record appearing multiple times. So it looks like, for example, someone had multiple criminal cases when really there was just one. We also see the reporting of obsolete information, and that's kind of a technical term that we use with the Fair Credit Reporting Act. But under the FCRA, certain records can't be reported for more than 7 years. Maybe most relevant here, one of the most relevant things here are non-conviction records that are older than 7 years can't be reported. So you could see an old non-conviction record appearing on a report, which is an error. So why why are these so full of errors? Why does this happen? There are a lot of reasons, and I'm really going to focus on the ones that have to do with public records as opposed to credit reports, because often in the tenant employment screening context, these are really big deals. So part of it is that the companies include outdated records or stale data. And this can happen for a lot of different reasons. Some of it has to do with they might be using a data wholesaler who doesn't regularly update their records. They're using a giant database of records, and it's unclear how often that is updated. And this is related to the second bullet point here, which is reliance on records not from the courthouse. So if you're not just going directly to the source, or you're a background check company that doesn't take an additional step, maybe they just run a search through a giant database and then that's it. They don't go to the courthouse to get records. You can see how that would result in the use of out-of-date data. And similarly, we see a lot of automated screen scraping, and that can ignore updated information in a docket too, like disposition information, for example. Um, Part of some errors come because of what we call sloppy matching practices. So, in order to figure out who the record belongs to, these tenant employment screening companies use matching techniques, and what they're using as their matching criteria can determine the error rate. So, for example, if you're only using first name, last name, and date of birth, you might end up with a lot of records that belong to somebody else, especially if, as we recognize in the last bullet point, you're relying on partial matches as well. So you could pick up a lot more records if the names are similar, or you're only using the year of the birth rather than the entire thing. So to sort of sum it up, a lot of errors happen because of these sort of third-party data brokers and reliance on this broader data economy rather than just going to the courthouse and verifying things. So I'll stop there and see if anybody else wants to add anything before we go to the next slide. Okay. So under the Fair Credit Reporting Act, consumer reporting agencies, the tenant and employment screening companies, actually do have a lot of duties. I would say to me, the most essential one is they have to follow reasonable procedures to assure maximum possible accuracy. And so a lot of litigation around the FCRA is focusing on how they did not follow reasonable procedures to assure maximum possible accuracy. And we call these EB claims because they're from 15 USC 1681 EB. Another duty, like I was sort of mentioning earlier, they can't report adverse information or records that are older than 7 years, other than records of convictions. Yes, go ahead, Sparky.
Well, can I just jump in here because I know we have uh, highly or almost exclusively California audience. We'll talk about this in a later slide, but under state law, they can't report convictions that are older than 7 years either. And actually, under state law, they can't report adverse criminal records other than convictions at all. If it was just an arrest, they can't report at all. So that's one of the differences. I just want to flag that for California people.
That's super helpful. Thank you. And that's also a good flag that, when you're thinking about bringing California claims versus claims under the federal law, that's a really big point of difference. And there's like a special allowance for California to be able to do that essentially. So if for some reason you find yourself in another state, don't assume that your state can do that. But thank you for that. That's super helpful. And I also want to just quickly mention that 1681K, which is only relevant in the employment screening context, requires strict procedures to ensure records are complete and up to date. And there's also some intricacies here around when this applies. But note that that's only for employment. And I will say, as sort of a side note, under the Fair Credit Reporting Act, employment the employment context comes with a few more duties and remedies than the tenant context. They're weaker. The law is weaker in that other context. So just be aware of that. They're not the same. Another obligation for CRAs is under 1681I, which is the CRAs have to do a reasonable investigation of a consumer's dispute. And we'll go into what a dispute is in a little bit. But basically, the idea is that if you see an error, you can dispute it. And when you do that, the CRA has obligations to investigate. And then the last one that I'll talk about now is, as Chi mentioned, under 1681G, the screener has to provide a file disclosure upon request, which is the information that they have. And this also importantly includes a requirement that they provide the sources of the information, which can be really important if you're trying to correct an error. You want to know where the error came from so that you can actually fix it across the board with more than one screening company. And with that, I will turn it over to Chi.
Thanks, Ariel. So under the FCRA imposes obligations not just on the consumer reporting agency, but on the users and furnishers. So the other actors in sort of this ecosystem also have duties. With respect to users, remember this is the landlord or the employer in the context of tenant or employment screening. The two main buckets of duties are the requirement to have a permissible purpose and then the notices. So, permissible purpose. One of the roles of the FCRA is it's a privacy statute, and it limits what entities can receive or obtain a consumer report. You can't just be some random person on the street and get someone's credit report or tenant screening report or employment report. You need a permissible purpose. Now, that being said, the permissible purposes are pretty broad because it includes credit, insurance, employment, and this catch-all of legitimate business need for a transaction initiated by the consumer. That is what tenant screening usually falls under, and a whole bunch of other purposes. Government benefits and licenses is also a purpose. Review of a portfolio for investment purposes. It's the permissible purposes are pretty broad, but the entity needs to have one. And what's not a permissible purpose is marketing. Then the other bucket of duties is notices. So all users, if they take an adverse action based upon a consumer report, they have to provide what's called an adverse action notice. That includes landlords, employers, creditors, etc. However, really important caveat, the requirement to provide an adverse action notice is not privately enforceable. So only government actors can enforce that. Now, as Ariel mentioned, there are special duties imposed upon employers when they use a consumer report. For example, employers actually have to get authorization from an employee to provide to use a consumer report. That's not true for all the other permissible purposes. And actually, the consumer's authorization itself is a separate permissible purpose. But with employment, employers have to get the employee's consent. And if they're going to take an adverse action, like they're not going to hire the person or they're going to fire or not promote them, they have to provide them with a pre-adverse action notice. They actually have to provide ahead of time a copy of the report and a summary of rights. And that particular duty is privately enforceable. There are these extra protections in the employment context. Now, adverse action notices, even though there's no private remedy with respect to anyone else except an employer, they are important because the information within them will tell the consumer that they have that a consumer report's been used, that they've been denied housing or a job because of their consumer report, which consumer reporting agency supplied the information. And that gives the consumer the ability to figure out where to get their report, review it for things like errors. So it's sort of the teachable moment or the trigger oftentimes for when a consumer realizes there's something wrong with their consumer report. Next slide, please. Now the other category of actors, furnishers, also have obligations. The section of the Act that governs furnishers is primarily 1681 S-2. And S-2 has subpart A and subpart B. Subpart A has a bunch of duties, including requirement or prohibition against furnishing information that the furnisher knows or has reasonable cause to believe is inaccurate, and requirement to investigate disputes sent directly to it, but it has no private remedy. The only private remedy against furnishers under the FCRA, for the most part, or the most important one, is 1681 S-2B. And this is the requirement that a furnisher conduct a reasonable investigation of a dispute referred by the Consumer Reporting Agency. So earlier, Ariel mentioned 1681I is the consumer's right to dispute with the CRA. When that is triggered, the CRA refers the dispute to the furnisher. The furnisher has duties to conduct a reasonable investigation. And if they don't, then there's a private remedy for that. Now, that is a hurdle for consumers who are trying to address errors in their consumer reports. However, you in California have a special right that Sparky's going to talk about under state law, and only UMS and possibly Massachusetts has that. So next slide, and I think next slide is yours, Ariel.
We've got a question in the chat. I don't know if we want to do this as we go, Gigi. Well, either of you, I guess. The question from Stephanie is there a remedy if the company doesn't respond to a file request?
Yes,
Okay.
we'll get to that. It is tricky. Um, we'll say that for now. This is unfortunately now I wish I could just say, yes, it's super easy. That is no longer the case because of Article 3 standing. But we'll get to that. So once you have a file or the report, you have to review it for inaccuracies. And those are looking for all the things we've talked about. And part of what you should be doing next, if the inaccuracy arises out of some problem with a public record, a criminal record, or an eviction record, you should get any underlying court records. And I would say that the best practice is to submit a documented formal records request through the particular court's process and to get a formal response certified if possible. I don't know if Sparky has anything specific to say about California courts, but that's sort of what I would say. And the records should include the proper classification of a conviction, for example, if it's a misdemeanor, disposition information. When it comes to expunged records or mismatched records, you might be able to get some sort of letter that says there are no records on file for a person with your client's personal identifying information. That's sort of tricky. What you're trying to say is there's an absence of a record, so you might want to figure out that. Then you have to actually deal with the inaccuracies, and that this is the dispute process that I referenced later. And the best practice is making a detailed dispute of any erroneous or otherwise improper information. And there's some debate among Fair Credit Reporting Act lawyers about whether the client or the attorney should do this. A lot of folks say the client should request the rate investigation in writing. And this letter should include things like the client's full name, addresses within the last 2 years, date of birth, telephone number, social security number, spouse, if any, and current employment information. And it should also include a copy of the tenant employment screening report, and if it's relevant, a copy of the public record obtained from the court, a statement that the inaccuracy or completeness of something is disputed or challenged, and an explanation of that error and omission, and a request that the screener delete or correct the information. And I should say that's a lot of things I just told you. We will be sending in the materials an article on our digital library that specifically says this in writing, so that you can see a little bit of that. Um, One thing I also mentioned is the fact that this could happen again if you don't address the source of these problems. So, one way you can prevent recurrence of the same issue is from getting disclosures from the other big players. And also, if you know there are certain tenant or employment screeners that are really prevalent among your clients or in a certain place, you might want to request files from them and then try to deal with it. And even more to the root of the problem is to dispute with any identified vendor sources. So, as I mentioned, when you get the file, you should also get the source of the information. So if you learn that LexisNexis is really the reason why there's an erroneous record, it makes sense to correct with LexisNexis. So go through the dispute process with them. They are, as Chichi mentioned, a really big provider of records, especially eviction records. So keep that in mind, that should be part of it. Um, and we'll just see if anyone else, I don't know, Sparky, if you have anything to share from practice about how you do disputes that might be helpful to your fellow Californians.
Um, well, I do have a couple things to say, although I think I have the next slide, which is it time to litigate? So maybe that's um yeah, so I think like as both Chichi and Ariel alluded to, like there are a lot of different ways that people go about the process. Um, so I don't necessarily think that there's a right way. I will say like when you're dealing with this stuff, right? Like yeah, generally you're going to need or want to dispute. Even if you are going to operate under California law and sue where no dispute is required, usually like it's a good idea to dispute anyway, because as we're going to talk about when we get to the remedies, right? Like you might want to show a willful violation. And if they don't correct in response to a dispute, that's helpful. And if they don't correct in response to 3 or 4 or 5 disputes, that's even better. Um, and also, they might fix it in response to a dispute, and your client probably needs it to get fixed. So, usually, even if you're going to be operating in California law, you do want to dispute. So, when do you litigate? I mean,
Sparky, can I say one more thing that brought
please,
up for
yeah.
me? Is that I think that's a really great point about what your client's most pressing needs are. And getting it fixed is probably a really big one because it impacts their life immediately and going forward. And, we're talking about when do you litigate and how does that go? But, your client might have a really pressing need for housing right then. And so, the FCRA and California law are sets of tools, but there's also sort of the practical aspect of how do you get something corrected really quickly? How do you show a landlord or employer it's wrong so you can potentially get them into that apartment or get them that job? So, I think keep in mind those sort of practical aspects that kind of use the law but don't go as far as litigating. I think those are, yeah, those are essential to think about too.
And that joins up with the litigation too, in a way, because usually the things that are what is actually going to get this fixed are providing the information that would lead any reasonable person to fix it. And so when you put that in your dispute, you're both hopefully maximizing the chance that it actually gets fixed, but also making your case way better if it doesn't get fixed. Because, when we were talking about before, like all the different stuff that you want to put in your dispute, that's not all necessarily like legally required to be a dispute. But the point is that you want to make it very, very clear, right? This is wrong. Here's the proof that it's wrong. You can't really deny it, right? And so if you come back and tell me it's not wrong, that's exhibit A, right? That's exhibit one to the jury. Is like, here's my dispute letter where I explained every single thing. Um, that's kind of the practical thing. So as I say, a lot of people will not even litigate after the first dispute. They will do 3, 4, 5, 6 disputes. You could do different kinds of disputes. I like to have my clients do phone disputes. Um, and record them so that I have a record of what was said. In California, they have to disclose that they're recording, but they can do that. Usually the CRAs don't hang up on you if you tell them that you're recording the phone call. Um, we kind of talked about the request for files and how that can be a complicated Article 3 problem. I mean, but if the person's asking over and over again, and if they have a good reason for it, and also just a note, right? If you don't have Article 3 standing in federal court, you might get remanded back to state court, and you might be able to proceed in state court, in California at least, for now. And then, you want to just also look for the same fact patterns with the same CRAs, right? So, you know, there are background check companies that are really bad about updating their records, and they will just miss expungements. And I've had multiple cases against the same company on basically the same fact pattern, right? Where I know, yeah, I mean, I can dispute, and maybe they're going to fix it in response to the dispute, but I'm probably going to sue them anyway because I know the 5 things they did wrong. I know exactly how they screwed it up, because I know that they update their records like once a year, and the California statute says you have to look within the last 30 days. Um, so, again, recognizing that you all, or most all of you, are legal services, the calculus here is maybe a little bit different from what it is on the private side, but I think the steps that you're going to take are basically going to be the same, which is you probably just want to get it fixed for your client at the outset. So you're going to do a good detailed dispute, and you're going to provide the proof. And if you get a denial on that dispute, then you're going to start to think about litigating.
So let me just add in terms of Article 3 standing. So I'm, not going to go into detail because that's sort of above the level of this particular webinar. But in general, we've been advising that if it makes sense to start in state court, so that if you do get dismissed on Article, if the case is, ends up in federal court, and then there's an Article 3 challenge, the worst thing that'll happen is a remand versus the case being dismissed. Now, I think in California, there's some not great case law about standing in state courts under the FCRA, but better case law under the California Act too. So that's another reason to consider California claims. I think the next slide is me, damages. So now we're back to the federal FCRA. So the federal FCRA does have private remedies for many of its provisions. We've talked about some that don't, but some of them that do are 1681EB, the requirement for reasonable procedures for maximum possible accuracy. 1681I, the requirement to conduct a reasonable investigation of disputes. Violations of those sections do have a private remedy. Now, the private remedy, it's important to note, is for negligent or willful violations. The FCRA is not a strict liability statute, for a couple of reasons. One is the accuracy requirement is to follow reasonable procedures. So just because there's an inaccuracy on a consumer report, it doesn't mean there's a violation. It doesn't mean that you're going to get lots of damages. It could mean that, depending on what caused the error and how bad the failure to follow reasonable procedures was. But you need at least negligence, and a negligent violation will get you actual damages and attorney's fees. And remember, those are the damages that happen from the violation. So if the violation is a failure to conduct a reasonable investigation, the damages are for after the failure to conduct a reasonable investigation. So unfortunately, if the client lost the job, disputed, and the error didn't get fixed, the job loss might not be addressable under a 1681I claim for failure to conduct a reasonable investigation. That you'd have to bring a 1681EB, failure to follow reasonable procedures for maximum possible accuracy, in order to get redress for the job loss.
Or state law.
Or state law. That's right. That's why we have you here, Sparky. You keep reminding us of the excellent California laws you guys have. All right. Now, if there's a willful violation, you can get statutory damages instead of actual damages. I think that should say actual or statutory damages, and that's my bad. Or you might be able to get punitive damages. A willful violation is a violation that is either knowing or in reckless disregard of the law. And that comes from the Supreme Court's case, Safeco versus Burr. The Supreme Court said a reckless disregard is also willful, but obviously that's a higher standard than a negligent violation. And that particular provision, 1681N, will also give you attorney's fees and court costs. One thing you probably can't get under the FCRA, but you may be able to get under the California law is injunctive relief. Most of the case laws pretty much said the federal law does not allow for injunctive relief, but you can get it under California law. And hopefully, Sparky, you'll mention that, or you'll talk more about the relief involved under those laws. Okay, next slide. That's you, Ariel.
It's me. So one last note on if you decide to litigate, I just want to flag that there is a very robust plaintiff sidebar that, including Sparky, that brings FCRA cases, and it's really worthwhile to talk to them. There are a lot of reasons. One, they will know what all the flags are around things like standing. There are some really intricate issues going on right now in this space, and so they will let you know about them. There's also the possibility that if you don't have the capacity to take it on, they will take it from you. There's also co-counseling. We have seen a lot of really fruitful partnerships between private attorneys who do this work and legal aid folks. And I think that that can be a really great way to start working in this space is through a partnership like that. All right, Sparky, California law, more claims, more remedies.
Yeah, well, and just a note on the co-counseling point. You all can just call me. I mean, I'm looking at the list. Several of you have before, and I'm grateful. Like, if you have questions about this stuff, it doesn't have to be, oh, I'm at the point where I think I need to litigate this, or this is super developed. Like, I and basically every other lawyer who I know who does this in California is so happy to talk to really anyone, but especially legal services attorneys about this stuff. You can just call me or email me anytime you have questions about this. Okay, Chi Chi, do you actually want to start by talking about the preemption a little bit?
Yeah, so Sparky's going to talk to you all about the wonderful California law. But whatever you're talking about, a state credit reporting law, you have to think about preemption. Preemption under the Fair Credit Reporting Act is messy. It's complicated. It's god awful. There's three different types of preemption applying not only to different sections, but different subsections of the FCRA. And they're under debate. So the credit reporting industry will claim that any state law that regulates the contents of a consumer report is preempted. We don't think it's that broad. We think it's only certain things that are preempted, like state law limits on obsolescence. The Biden era Consumer Financial Protection Bureau agreed with us. The Trump era CFPB unfortunately did not and issued a bad interpretive rule about this. We have an article sort of providing a primer on preemption and discussing why we think the Trump era CFPB is wrong. That'll be in the materials that are sent to you and follow up. If you ever have any questions or encounter issues with FCRA preemption, give me a call or email me. My email's at the beginning of this PowerPoint. Happy to answer them. This law is under flux, and we want to try to make as best case law as we can. The other exceptions to preemption are there's a set of laws that were in place before September 1996 that are not preempted, and those include some important California provisions that Sparky's going to talk about, including the Massachusetts and California provisions on furnishers. So over to you.
Yeah, so that's the big one, right? Because like Chi Chi was saying before, I mean, the Fair Credit Reporting Act, in order to get to the furnishers, in order to get to the people who actually provide the information, you have to go through the dispute process, and the violation is about the dispute process. In California, there is a specific provision, which is Civil Code 1785.25A, A furnisher can't can't report information that it knows or has reason to believe is inaccurate. That is independent of any dispute that you've done. So, if, for example, Kimball Tyree comes and reports a amount of back rent owing that it knows or should know that's not true, maybe because there's a judgment saying $0 back rent, you can certainly dispute that and create more claims for yourself, but you already have a claim potentially under 1785.25a. There is a private right of action. There is no dispute required to trigger liability. That's kind of just the main chunk nugget of the CCRAA that is, usable, not preempted, and really powerful in California. The remedies for that, you can get actual damages. You can get punitive damages of up to $5,000 for willful violations. It's got the same division as the Fair Credit Reporting Act between negligent and willful. Negligent gets you actual damages. Willful can get you punitive damages up to $5,000, maybe per violation. Some question about how you define violations in the context. You can also get injunctive relief, and of course, you can get attorney's fees. So it's a really, really helpful addition. And we're already at 12:55, so I'll try to be a little faster. Okay, so tenant case example, kind of like I just mentioned, you might have a stipulated judgment for move out only. I've seen these where the judgment will actually say $0 back rent, and yet the landlord and or a debt collector will report a back rent due. That might show up on some tenant screening reports, that will often show up when it goes to a debt collector on the big three credit reports. These, you will have claims here against the landlord and the debt collector who should know that the back rent is not owed. Go next one, Ariel. Or Kaja, I'm sorry, I can't remember who's doing. Could you do the next slide? Yeah, thank you.
It was just delaying. I got it.
Okay. The Investigative Consumer Reporting Agencies Act, called ICRA. It's kind of, I don't know if I say ICRA. So we already kind of covered this, but it basically covers all background checks and tenant screening, pretty much. And it includes reports that rely exclusively on public records. As Chi-Chi was saying, and Ariel was saying, there's often a data broker that sits in between. Sometimes they'll try to hide that from you. Sometimes they'll not disclose that as a source. I've had companies that have said, oh, that's super confidential proprietary business information, where we get the data. You get all kinds of kind of BS from them. But all of these are almost certainly covered under ICRA. Next slide, please. ICRA has, like the Fair Credit Reporting Act, it has permissible purposes. I mentioned this earlier. We don't have to go over it in detail, but employment and tenancy are both allowed, as well as insurance and some investigation stuff. There are some common procedural violations. So there generally is a standalone disclosure that you have to make under the ICRA. Also, and there's a standalone permission you have to get in the employment context. You don't have to do that in the landlord context, but if a landlord is going to use a report, they do have to give you a checkbox where you can check to say, I want a copy. And they often don't do this. It's kind of interesting. There are a lot of landlord violations that are hard to ferret out, because a lot of times landlords will deny people based on a tenant screening report, but then just not tell you. And so then you don't know, and you don't know if there's something inaccurate in there, and that's a violation of the law. But how would you know? One way you know is that they charged you a background check fee to apply. But that's something that I feel like happens a lot more than actually gets enforced. You really have to dig for it with people to figure it out. Next one. So again, like the Fair Credit Reporting Act, ICRA has obsolete. You can't report obsolete information. It defines it a little differently, right? So bankruptcy is older than 10 years. Suits, judgments, tax liens, older than 7 years. Records of arrest, indictment, or criminal charges that did not result in conviction cannot be reported at all in California. So if there's no conviction, there should not be an arrest on a report. That is allowed under the Fair Credit Reporting Act. Is not allowed under the Investigative Consumer Reporting Agencies Act. Convictions can be reported, but only for 7 years. And the 7 years runs from disposition, which is usually like the time that the conviction is entered, release, or if the statute says or parole. Now, for a long time, people interpreted that to mean the end of parole. There's a California Supreme Court case from a few years ago that says, no, that actually means from the Supreme Court or published appellate opinion. I can't remember which. That means from the beginning of parole. And so, again, it's important to look at this and to see, are they reporting something that is too old, a conviction that is too old? And I've had those a number of times. They cannot report expunged or sealed records. Another huge difference with the Fair Credit Reporting Act. I just saw a bad case in the listserv this morning about expunged records under the Fair Credit Reporting Act. Much clearer in California. If a background check has an expunged record on it, it is inaccurate.
And Sparky, going
Yeah.
back for a sec to your point about the checkbox for landlords about whether
Yes.
someone wants a copy, someone in the chat is asking where does that have to appear on the application?
I'm not sure exactly where it has to appear, but I think generally it does appear on the application. It should appear somewhere in the same process as when you're, they almost all charge a fee for this, right? So it should be somewhere in there. There are also other questions like some landlords maybe don't have the checkbox, but they actually automatically send everyone a copy. Is that a violation? I mean, maybe technically, but I don't know if anybody would litigate that. Um, so it's not a definitive answer. I don't know exactly off the top of my head what the statute says, but there should be a checkbox somewhere when you're applying that gives you an option to get a copy.
So I would just jump in for a couple things real quick. So some of these provisions that are stronger than federal law are not preempted because they're September 1996. So in other states, there might be some debate about whether if a state adopted this kind of protection right now, whether it would be preempted. But you guys, because you had this pre-1996, it's definitely not. The other issue is sealed and expunged records is really complicated. And if you're not, if you're dealing with this under the federal law, please reach out because it's not settled. And we are hoping to keep these kind of records off of reports nationwide.
And the last thing I'll say is there is no equivalent right under the FCRA for a landlord to give an applicant an actual copy of the report. You can get your file disclosure, but you can't get your actual report. So just remember that it's weaker.
Yeah, and I think the next slide is gonna touch on expungements too. Yes, so and won't necessarily need to go through all this in detail, but you have a right to receive a copy of your report or your file. I can't remember which term it uses. The report versus file in the ICRA context is kind of interesting because a lot of these companies will claim they don't keep a file, but they compile a report kind of like made to order. But in any case, if they make one about you have a right to get it. You have a right to dispute. They also have to maintain and follow reasonable procedures to ensure maximum accuracy. The third point under the second column is really important for expungements, right? For information from public records, the investigative consumer reporting agency has to verify the accuracy of public records within the 30 days prior to reporting. Okay, so if they are reporting a conviction, they have to have gone and actually verified the accuracy of that conviction record within the month before they issued the report. And so this really, it's targeted at this practice of buying really stale data from data brokers. And yet so many of them still buy very stale data from data brokers and do not comply with this. And I think I've got an example on the next slide. Yeah, so common situations under ICRA, just straight wrong person, right? It's a fuzzy search. They're not careful. I have one right now where, it's a first and last name match and a birthday match, but my client doesn't have a middle name, and the person they reported does have a middle name. And I don't know exactly what happened, but I think they just forgot to check the no middle name box. And so it pulled anybody with a middle name too. A lot of conviction is too old. Like I said, some will report from the end of parole instead of the beginning. I've also seen ones where they claim to have just mixed up, like they, reported a guy's conviction as having been from like 6 months earlier, when in fact it was from 15 years earlier. And they said, oh, we mixed them up with somebody else. But the biggest one is the expunged conviction continuous reporting. They use really stale data, and it seems to me, rarely actually verify 30 days prior. Next slide. Again, this is a little bit repetitive, but I've seen expunged conviction reports months, years after the expungement actually happened. Seen the end of parole date as the release date. I've seen, middle name. Those are all the things that I just mentioned. So go to the next one. Right. Remedies. Remedies under ICRA are good. So under ICRA, for any violation, you can get actual damages or $10,000, whichever is greater. It is semi-strict liability. It's not a negligence standard exactly. There are some negligence type language built into some of the provisions, reasonable procedures and that kind of thing. But the actual remedies provision says any violation of the statute. The $10,000 minimum does not apply in class actions. I don't think that matters to most of you, being legal services and many of you LSC funded. But that $10,000 is a nice starting point. Actual damages or $10,000 for violations. Of course, you can get fees and costs, and you can also get punitive damages for willful violations. I can't remember off the top of my head if you can get injunctive relief. I think maybe not, but I always include a 17,200 claim to kind of throw in some injunctive stuff anyway, in most of these cases too.
All right. Thank you, Sparky. That California law sounds great. So just a plug for if this webinar has made you very interested in the Fair Credit Reporting Act or consumer law in general, we have a training at the end of April, beginning of May in Minneapolis. We have both an FCRA track, as well as, for those of you who do tenants' rights work, an entire track on consumer rights for tenants, which also includes topics such as rental debt, junk fees in the rental context, and more. And then next slide. Oh, by the way, the early bird registration for that conference is, I believe, the 20th. So if you're interested in the conference, that's the deadline to save some money on the registration fee. And then, as I said, we do have scholarships. We have 10 scholarships for legal services attorneys who have not been to the spring training before in the last 5 years, and certified that they are or intend to work on FCRA issues. I can tell you right now, I think we're going to have a lot more applications than scholarships, but please get them in, because 10 lucky folks will get a scholarship. And also, knock on wood, we hope to be able to do the same for the Consumer Rights Litigation Conference that we put on in the fall. So with that, I'm going to turn it back over to Kasia with LAAC.
Yes, thank you so much for that wonderful presentation. I'm going to reshare the link to the slides in the chat, because I know there were a lot of citations that everybody's going to want to dig into in there. We'll also be following up with MCLE certificates within 1 week to the email address that folks use to register for this event. Thank you again so much for this presentation, y'all. This was wonderful. And we'll be posting the recording for this on our website within 1 week.